Hi, and good afternoon, everyone. My name is Tanya Evans, and thank you for joining us for today's update on Fair Work and the Work Health and Safety Update, which will be delivered by Amy Towers and Ali from Risk Collective and Ali from Dentons. Just before I get started, there's close to 300 people on this webinar, so given we've only got 30 minutes and there's quite a lot of material to get through. If you have a question during the webinar, please just pop it in chat. I really doubt we'll get time to get to these questions, but I'll have a quick glance over, and if we do, we'll try to get to those questions at the end. Otherwise, don't fear, pop your questions in there, and our team will work with Amy and Ali to answer those questions and include them in the webinar with the webinar recording at a later date in the next couple of days. For those of you who are not familiar with WorkPro, WorkPro is an online workforce compliance platform, and our area of specialisation is to offer you a solution, or employers a solution, whereby they can get their candidates job ready quickly, background screening, e-learning inductions, collecting licenses and tickets, so what we call all the boring admin bits about the recruitment process, and we streamline that on behalf of our employers to make that process simple for the candidate and employing entities. As far as, before I introduce my two guests really quickly today, we're going to spend, like I said, about 30 minutes getting an update from Amy relating to work health and safety, and Ali will provide an update around Fair Work. So without further ado, thank you ladies for joining me, Ali and Amy. We've been working with Amy and Ali for quite a number of years. Amy, from a work health and safety point of view, writes and authors a lot of WorkPro's e-learning content, and Ali and Amy work together quite closely on consulting work for employee relations. Today, we are going to cover off some legislative amendments, particularly around Sex Discrimination Act and relating to respect at work. Employer obligations as it relates to training and hiring policies, and also the Fair Work legislation as it relates to closing loopholes. I know a lot of our audience today is super keen on hearing from Ali about that. And from Amy on a work health and safety update, we're going to start talking, I'm going to hand to Amy to talk about the Safe Work updated consultation guides, shared responsibility, a couple of case studies to really put into perspective what your obligations are as employers and help you implement some practical strategies in your own organisations, and also some case law. So over to you, Ali, and welcome, and thank you for joining me today.
Thanks, Tanya. Thanks for having me. And there is, as always, a lot of content to cover, so feel free to push me along if I'm spending too long on anything in particular. But my name is Ali, or Alexandra Tyrrell. I'm a managing associate at Dentons, which is a global law firm, and I work in the employment and safety team. And firstly, I'm going to start off talking about the respect at work changes, which have been in for a little while now, but I think it's always important to be talking about them, in particular because the Australian Human Rights Commission has some new powers that are going to be coming into effect mid-December. So no doubt we'll see more talk and movement in this area. But just to recap on the changes, and I guess by way of background, a lot of these changes came about as a result of the Australian Human Rights Commission undertaking writing reports that they do on surveys every 5 years, and they keep finding that 1 in 3 workers are experiencing sexual harassment in the workplace, which is a pretty big number. And so a lot of these changes are aimed at addressing that and trying to make organisations and employers really proactive about preventing sexual harassment, sex discrimination, because it was their view that the legislation as it was really focused on conduct once it had already happened. So sexual harassment occurs and then someone complains and then they address it. But the idea is we look at it with a health and safety lens and we prevent this behaviour from happening in the first place. So the most significant change has been, oh, sorry, Tanya, I'll just get you to go back to the other slide. The most significant change has been the positive duty, which is the duty that employers need to take what we call reasonable and proportionate measures to eliminate sex discrimination and sexual harassment. what that means for one business is probably going to be different to the next. And the Human Rights Commission, when looking at this, will look at the size of your business, your resources, all that sort of thing, to see if you are complying with that new positive duty. Another change is sexual harassment disputes. The Fair Work Commission can now hear complaints about sexual harassment, and they can conduct a mediation or conciliation about it. And if it's not resolved there, it can actually be taken on to the federal courts, much like the general protections process, if anyone's had experience with that. Another change is that there's some additional protected attributes under the Fair Work Act, and they are breastfeeding, gender identity, and intersex status, and that's for the purpose of adverse action. So it's unlawful to take adverse action on the basis of breastfeeding, gender identity, and intersex status now. That's in the Fair Work Act as well. And as I said, as of 12 December, the Human Rights Commission is going to have new powers around the positive duty. They're going to be able to conduct inquiries, and they'll be able to issue compliance notices if they come into a business and see that the business is not complying with its positive duty. And if they issue a compliance notice, then the business is still not complying, then they can take them to court and get enforcement of that compliance notice. So as I said, I think we're going to hear this spoken about more, and it'll be interesting to see where the Human Rights Commission sort of focuses its attention in the coming months.
Yeah, I just have a really quick question for you, Ali. And you just mentioned if the AHRC were to come into a business and determine whether an employer was meeting its obligations, how was that likely to happen?
Yeah, so I think it'll be interesting to see. I think I've read somewhere that they have targeted industries, and I know it included retail, it included law firms, which will be interesting. But I imagine that they will have limited resources, and so we'll be, looking into any complaints that they might receive and going from there. But the idea is the Commission can proactively go into a business and say, show me your policies, procedures, whatever it may be, to see what they're doing. So I'd say much like WorkSafe, they can go in and look at everything and take what steps they need. But resources are not endless, so I think they'll have to be pretty targeted in who they target.
No, thank you for that. All right.
And then very quickly on sexual harassment, it has a definition, it's on the screen. I won't go through it given the time restraints, but just to remember, it's unwelcome conduct, it's of a sexual nature, and it's not just physical, it can be verbal, it can be text messages. There's a whole lot of conduct that could amount to sexual harassment under the laws and therefore be unlawful. And on the next slide, I was just going to talk about a particular case which talks through sexual harassment, and I think really shows the reach that these sections can have. Not sure if anyone had heard of it. It got a bit of media attention a couple of years ago when it was handed down, but basically the applicant's name was Reem Yelda, and she was a customer liaison officer, and she went to work at Sydney Water one day, and there was this third party called Vitality Works Australia, and they're a health and safety provider. They were wanting to do a campaign on spine health, and they went up to Reem and said, can you be part of this campaign? And she said yes, and they said, all right, can we take your photo? And they did, and it's the photo that you see on the screen, but they didn't tell her much else about it. And Vitality Works then went away, created the poster that you see on the screen, and Sydney Water put it up in lots of depots and next to bathrooms. And key to this case, or part of it, was that it was a real male-dominated workforce, and so the applicant Reem felt very upset by this. She said she felt she was treated like a sex object, and she ultimately resigned. So she was really very much affected by this behaviour, and she said both her employer Sydney Water and Vitality Works had sexually harassed her. And so the court had to look at it and say, well, is this sexual harassment? And going through the test, which I just touched on before, they said, yes, it's unwelcome. She agreed to having a photograph taken, but she did not agree to the contents of the poster and what you see there. The court said a reasonable person would have anticipated that it would have offended her or humiliated her. And the court also said this is conduct of a sexual nature, and it came down to that word lubricate, and that it's a big word. It's the first thing you see it's not really clear what it means without reading the small writing. And so the court said, yes, it was conduct of a sexual nature and it amounted to sexual harassment. So I think that's just interesting to see the reach of these clauses and these parts of the Sex Discrimination Act, and to always remember that just because you think something's a joke or a pun, it could still be sexual harassment. The intent doesn't really matter at all.
Yeah. Yeah, and and clearly you can see here about each respondent was ordered to pay the complainant $100,000 so in damages. So it impacts across several entities, right?
That's right. That's right. So her employer had to pay, but also this third party. So again, it's not just the employer-employee relationship that these sections can reach.
Yeah.
So that's just an example of what could amount to sexual harassment. And on the next slide, I've just got a diagram, and this is from the Australian Human Rights Commission has released some guidelines, and the name of it is at the top, the guidelines for complying with the positive duty. And this is a huge document, but basically the Human Rights...
I think you said 112 pages? 112 pages, is that right?
So it is big, but I've got to say, I think it's actually quite helpful. And the Commission will expect businesses to have read this, and it goes through and provides examples about what you should do under each of the 7 standards. So you'll see there's leadership is a standard. And, the question will be, do your leadership understand these obligations? Have they read this guideline? Have they attended things like this presentation today? How have they informed themselves? So it's a big document, but I would recommend that you start there if you're wondering, what do I do about complying with this positive obligation?
Yeah, and Ali, we'll include the link. We'll include this link with the webinar notes as well to make it easy for people to get access to the document.
Great idea. Yeah, and another of the standards is knowledge. And if you go to the next slide very quickly, there's just another case which sort of demonstrates what the tribunals and courts are looking for in terms of compliance in this area. This was a pretty extreme case with some really explicit sexual harassment, and it involved a male grooming business, and a female went to work there as a beauty therapist. She was 27 years old, and over about 10 months her colleague sexually harassed her. And as I said, it was really extreme, and I won't go into all the details, but they were, making suggestive comments and jokes. He put his legs between her legs, and the last straw was that he put his face between her breasts while she was lying back and having her hair washed. So pretty extreme behaviour, and she, unsurprisingly, alleged she had been sexually harassed. The court said, yes, that is sexual harassment. And then the court said, what did the employer do to prevent this? And the employer had a policy, but it was just, somewhere on an intranet, and it had been, referred to in one team meeting, but more or less it was not implemented and people weren't aware of it. And so the tribunal said that is not enough. Just to have a policy sitting there, you need to have the policies, but educate people on them, talk about them, do the training to reinforce it, monitor the workplace to make sure that, if there is any unacceptable behaviour, it's dealt with in a timely way. And in this case, the tribunal awarded the applicant $150,000 in general damages for the sexual harassment. So an example of the types of things that the tribunals are expecting, and this case is from a year ago now, so I think the expectations will only be increasing.
Yeah. And these things don't have to be onerous as well. There is opportunity to, in a practical sense, to deliver this information, keep people informed, and make sure they understand the reporting hierarchies that are available to them. It doesn't have to be onerous. It sounds like it, but in speaking to you, it really doesn't.
Yeah, that's right. And reporting's another really good point to touch on. That's something else the Human Rights Commission is looking at. Do people know what to do if they have an issue? Who can they talk to? Those guidelines that you'll send a link around for go through all of that and give you lots of ideas about things you could be doing. And small businesses will not be expected to do what massive corporations are expected to do. So that's worth bearing in mind as well.
reasonably practicable. Is that kind
yeah,
of what comes to mind?
yeah, some proportionate measures. So yes,
Yeah,
that's right. Some
that's
great
awesome.
lawyer.
Thank you. And finally, and I know that you know, I specifically asked you to include this in one of your slides, but the closing loopholes. There is so much media attention around closing loopholes. We talk about the proposed amendments. In some cases, it's highly likely that the proposed amendments will come through as legislation. But in speaking with you earlier, you're going to not touch on all of this, but I think the labour hire part of that is probably the most complex. We're not going to go into it today, but you're just going to touch on it at a high level if you would.
Yeah, that's right. So this bill was introduced in September and there's been so much talk about it. Some bits are less controversial, but some bits are very controversial, and there's huge concerns about the possible impacts on the economy. And so there's a report due to the Senate on, I think, the 1st of February about this bill. So we're not going to see anything come in before then. But now there's lots of debates happening and lots of media about it, and lots of, you know, unions talking about it, and obviously employer groups talking about it as well. And so I'm just going to touch on 3 of the proposed changes. And like Tanya said, I think they're probably all going to come in. It'll just be what form and what will the detail be, but I think probably the ideas will come in. The first one is that there is proposed to be really strict penalties for intentional underpayments. So the penalties are going to increase, and they're on the screen, but also it's going to be a criminal offence. So it could be 10 years in jail for intentional underpayments, which is pretty scary. But the explanatory memorandum to the bill does say that underpayments that are accidental, inadvertent, or based on genuine mistake are not caught. So it's scary, but you know, if you misclassify someone under our very complicated modern award schemes, then you know, hopefully that is not going to be caught by these sort of provisions.
Sure. Yep. Deliberate? Would you say deliberate is intentional?
Yes, yeah. I mean, I think it has to be quite deliberate. You know, it would have to be. You don't necessarily have to know the modern award rate is $23.50, but if you're paying someone $10 an hour and that could never satisfy minimum requirements, then I think that's the sort of behaviour that will be. It doesn't even pass the common.
It doesn't even pass the common sense test.
Exactly. So I hope this will be reserved for very obvious situations. The middle one on the screen, equal pay for labour hire firm employees. This is super complex, but basically this could apply where you've got your labour hire employer and they provide workers to a host. So let's say the labour hire employer has truck drivers and they send them to a mine. And the mine has an enterprise agreement. And if the mine's enterprise agreement applied to that truck driver, then in those situations, the Fair Work Commission might be able to make an order to say that the labour hire employer has to pay the same rates as under the mine or the host's enterprise agreement. So the idea is that you've got people performing the same work getting paid the same, as opposed to the people employed by the mine on this higher rate and the labour hire employees on this lower rate. That's the idea. How it's all going to work in practice is still sort of unraveling, but I think that's one of the more controversial changes and concerning changes, and how it's going to impact the economy. But that's the idea of it. There are some exceptions if the host employer is a small business, if it's for a really small, like a 3-month project or something, it might not be caught by these provisions. So there are some exceptions to it. And lastly, redefining casual employment. So the previous government amended the Fair Work Act to try and make the casual employee definition really clear. And it basically said if you agree that you're casual at the start of the employment and there's a few other things met, then you're a casual. Our current government sort of wants to unravel that. And the new definition you'd need to be looking at the actual relationship. So what does it look like? And that can be really difficult because there's no certainty, and you know, employees could turn around at any point and say, no, you know, I think I'm a permanent because this is what's been happening in reality and practically. And that's where casual conversion is also possibly going to be changed, where they can say that to you. They can say, no, I think I'm now permanent, and the employer will have obligations to respond to that. And ultimately the Fair Work Commission could look at it and manage a dispute on that topic. So casual employees is going to be another big change if it does come in the way it's currently drafted.
Yeah. And I look forward to sharing some updates with the audience as these proposals come through. So I look forward to having a chat with you, perhaps in February or late or early March, Ali.
Yeah, absolutely.
Yeah. That kind of concludes, and thank you so much for joining us today, Ali. That was such a great summary of what is going on at Fair Work and the closing loopholes. Really appreciate your time. I'm now going to switch tact and move into an update from Amy Towers around work health and safety. Thanks, Amy.
Thanks, Tanya. Thanks for having me. I love Ali's points around the sexual harassment because it very closely aligns with the proactive approach that businesses need to be undertaking for all other workplace hazards. And there's a really clear crossover there, just very quickly, in that while it becomes an issue on the employment relations side, it is deemed also a work health and safety issue. So it's something that work health and safety regulators can issue notices for as well.
Cool. Thank you for that nice little segue into updated consultation guides.
Yeah, so look, I wanted to raise this one today because I think it's an area when I work with a lot of businesses, it's something that they're not familiar with. So every business has a primary duty of care, which is essentially to look after their people. What a lot of businesses aren't aware is there's, in addition to your primary duty of care, there's another obligation that sits in the Act, which is a duty to consult. And so this tends to get missed a lot. And so I wanted to touch on this today because Safe Work Australia, who's the body that sits above all of the state-based health and safety regulators and sets up the mirror legislation or the model legislation and guidance material, they've gone away just recently and updated their consultation guides. So if you haven't already checked this out as a business, get onto it. It's absolutely crucial because what the guides do, rather than you having to go and read the legislation and read the section on what is consultation, who do I owe a duty to, these guides are the guides that help you understand what that means and interpret that. And there's some awesome examples that they put in there. So the Safe Work Australia Guide for Consultation talks about what a business's consultation obligations are. So they've revised that and they've put a checklist in there. And I love a checklist because what that does, rather than, I mean, you can read through the whole guide itself, but it's almost like a cheat sheet at the end where it's a quick self-assessment that you can use. And I just think that's so easy to do. So you can become overwhelmed reading through that guide. So we've got a link there. We're not going to click into it today, but use that. Use that to understand what your obligations are and to see if you're fulfilling your consultation obligations. Because if you're not, you're leaving your workers exposed, but you're also leaving your business exposed to litigation, and we don't want that. So that's a very handy checklist for every business to use. Again, it doesn't matter what size you are. If you've got one employee, you must be consulting. If you've got 2,000 employees, you must be consulting with every single one of those. So that guide is going to be super helpful to understand what that looks like for you. In addition to that, which I want to jump to next, if you want to jump to the next slide.
And we'll include that checklist link in the as a Q&A, guys. So don't be too worried about going to scramble and finding it now.
And so the other thing in relation to that consultation code and the checklist that's now being developed by Safe or updated by Safe Work Australia is it clearly explains the consultation obligation, not just to your workforce, but the consultation obligation that you have where there's multiple duty holders in place. So for some people on this webinar, they might already be familiar with that, but for others, it might be a new concept. So our health and safety legislation is pretty clever in that it recognises that not all business arrangement is employer-employee, that you can have arrangements set up where there's multiple duty holders. And that could even be, to give one example, that could be, say, a principal contractor on a construction site. Every subcontractor they engage becomes another duty holder, and both parties cannot transfer their obligation onto one another. They share that obligation, and there's things that must do. Now, where you've got more than one duty holder, there's this additional obligation to, and it's called, the easiest way to remember it is the 3 C's: consult, cooperate, coordinate. So you need to show that you're demonstrating that, working out who's going to do what. Another really easy example to use is, say you're a retail store and you're operating, so you're a duty holder, you have consultation obligations to your workers there, but you also are a tenant in that shopping centre. Now, whoever you're leasing that from, so your landlord, is another duty holder, and so they can impact safety. So you must consult, cooperate and coordinate with them. Then you could have shopping centre management, another duty holder. So in that example, you've got 3 duty holders. So the law says you each must work together to make sure that workplace is safe for your staff as well as customers, anyone coming into that environment. So this guide takes you through that whole process, and that check will make sure that you are considering who are the other duty holders that I need to consult, cooperate and coordinate with, and make sure you've got the right systems in place to do that.
Yeah, and just before we move on to a case study, just to let the audience know, Amy, you actually wrote an ebook for WorkPro, which is available on WorkPro's website, that is actually talking around shared duties relating to labour hire firms. So host employers. Yeah, so I don't know if you remember that, but you updated it more recently. So guys, if that's a free resource, that's available if you'd like to take a look at that ebook. Moving on to case studies. Amy, I know you've got a couple of practical examples for us.
No. So the other thing, just to help every business wrap their head around this, I think what Safe Work Australia has done really well in their update is putting 2 detailed case studies together. So the first one is really interesting. Again, we're not going to jump into each one today because you can go and look at that, have a read, digest it yourself. But the first one is a law firm who outsources their call centre to, or someone to take the calls and inquiries and manage that side of the business for the law firm. But that's an example of where the law firm can't transfer their obligations or just outsource their risk to another business. That law firm maintains its responsibility for safety, even for the outsourced workers that are not under their direct management or control, but they do have an influence on them because they're giving them a script to follow. So if their clients are abusing, verbally abusing that call centre staff's people, then that law firm has an obligation. So they've got to work with the call centre company on strategies to manage that. So that's a really good one to look at. The other one is a franchise case study. So it explains the role of the franchisor and the franchisee and how they would expect it to work together to look after the franchisee's people. So they're new. They're a really good way to understand that shared duty between multiple duty holders.
Yeah, that's awesome. Thank you for that highlight.
Yes.
And consultation, cooperate, the 3 C's, as you just mentioned.
Yeah, so this is just really reinforcing that where you do share a duty, whether it be subcontractor arrangement, whether it be sort of like a contracted arrangement, outsourced service, whether it be a labour hire arrangement, that you must identify those other businesses that you share that duty with, and be very aware that even with a contract, you cannot absolve yourself of those health and safety responsibilities. If you've got some influence and control, there is certain things you must be doing to exercise that duty. And often what it comes down to, and this is where that cooperation and coordination component comes in, is having that conversation with the other duty holders and saying, okay, who's going to do what? Who's best placed to do, say, a pre-site inspection, or who's best placed to deliver the training on aggression and violence? And without transferring that obligation, you're more sort of delegating who's the best party to do that. So just be aware that it is a legal obligation that you have if there's more than one duty holder in an arrangement in your workplace.
Yeah, perfect. Thank you very much. And some case law.
Yeah, so this is just one, but we've got it over 2 slides, and I thought this would just be helpful without going into the nitty-gritty details of it. Again, you can always look this up. Any prosecution is publicly available information for you to go and have a good read. But I just wanted to highlight this as an example of multiple duty holders and where you can't all your obligation onto one party. So in September 2019, there was a tragic incident that occurred at a construction site in New South Wales. There was a delivery driver who was killed when some heavy steel pipes fell from their truck and struck the worker on the head. There were 3 different companies who were involved in that particular incident, and they were all held responsible. So they each had a primary duty of care to ensure that worker was. And so you can just see here each of those 3 parties. The first one was fined $300,000. They were responsible for ensuring safety at the work site. They had safety procedures, but they failed to implement them correctly. So similar to what Ali was saying before about having a policy but not implementing it, this party was responsible for delivering the steel pipes to the site. They didn't consult properly with Force Fire and Safety and Hanson Newcomb, and they were fined $45,000. And the third party, who was also involved in the construction project, whilst they avoided a prosecution, they entered into an enforceable undertaking, which is like an alternative to a prosecution, but they're having to spend money on their own safety improvements. So that's an example where each party was held accountable for that, and they should have consulted, cooperated and coordinated in that situation.
And I just have a little question for you, and it kind of relates to records actually. You've got so many multiple duty holders, and they could be 2, they could be 3, they could be 5. You gave a great example before about a retail store. And then there's the record keeping piece. Is there any recommendations in the guides about how you would keep those records, who's responsible for those records, particularly as it relates to things like noting injuries and delivering training to the individuals?
Yeah, it's tough because consultation does not require record keeping, but how else do you show that you've consulted without your record keep? So obviously terms of business, as early on as you possibly can in an arrangement, in a business arrangement, identifying those in your terms of business would be really helpful. So not avoiding your obligation or trying to transfer, but it's coming to an arrangement about who will do what. It could be, a meeting that you have initially, but that guide is going to be helpful because while it won't say how you document it, it'll give you some ideas about different scenarios and how they recorded that. So it could be monthly meetings or quarterly meetings where you're doing a check-in and someone's keeping the notes of that.
Yeah, no, that's a great idea.
Yeah.
That is a great wrap up. Thank you. Thanks so much, Amy, for the work health and safety component of the session. We have just gone over time. We promised ourselves that we would keep this to 30 minutes. I think people start to wander off and their minds start to wander, and you guys have got really busy lives, so we won't keep you any longer. There is quite a number of questions that have been sent to us during the webinar. I've been keeping a little track of them. So as promised at the start of the webinar, we'll take those questions offline. I'll get Amy and Ali to answer those and then send them through with the webinar records, plus the links that we've included in this presentation as well. So thank you so much. Just to wrap up, thank you so much, Amy and Ali, for joining me today. That was super practical and gave a really well-rounded update on what's going on around fair work and work health and safety. So thank you very much, ladies.
Thank you.
Thanks.
That's all right. And we will we'll talk again in March, Ali, when we've got some of these maybe some more clarity around what's going on with this fair work legislation, particularly relates to loopholes. So I look forward to giving everyone an update then.
Yeah,
thank you
absolutely.
everyone for joining me today, and stay safe.
Thanks.
Bye. Thanks.
Bye.